What happens when the American justice system reaches its breaking point with delay tactics? You're about to find out, and the answer will shock you. Stay until the end because this reveals something extraordinary about accountability in America. In an extraordinary development that marks a pivotal moment in American legal history, US Marshals have commenced enforcement proceedings at a landmark Manhattan building. Federal agents, working alongside New York state representatives, presented themselves at the entrance bearing official documentation that permits the confiscation of property valued at approximately $540 million to fulfill an outstanding court obligation. This development represents far more than political theatre or symbolic action. The full authority of America's judicial framework is now being applied to a situation involving someone who once held the nation's highest office and has utilized every available mechanism to postpone compliance. The presence of federal enforcement personnel bearing seizure authorization signals that legal consequences can no longer be avoided. Make sure you're subscribed, because the developments in this case are evolving rapidly, and you won't want to miss what happens next. The catalyst for this unprecedented enforcement measure traces back to a court directive issued on January 17th by a Manhattan federal district judge. This order granted the U.S. Marshal Service authority to initiate property confiscation procedures following the defendant's failure to provide adequate financial security or alternative payment arrangements. This situation transcends ordinary civil litigation. We're witnessing enforcement actions against someone who previously occupied the presidency, facing potential loss of signature real estate holdings due to unpaid financial obligations. The appearance of marshals carrying court-issued documents represents a watershed moment in American jurisprudence. The broader context reveals an intricate legal saga spanning more than 2 years. The foundation was laid when the state's chief legal officer initiated proceedings in September 2022, following an exhaustive 3-year examination involving analysis of over 6 million documents and witness testimony from dozens of individuals. The situation intensified dramatically on January 15th, when New York's highest appeals court delivered its conclusive decision. The ruling rejected the final outstanding challenge and affirmed the initial $464 million determination, which has grown to roughly $540 million after accumulated interest charges. The appellate tribunal's 47-page analysis provided damning findings. According to sources who examined the complete ruling, judicial authorities determined that systematic deception occurred repeatedly across more than 10 years. The decision outlined instances where property assessments were inflated by percentages, reaching as high as 2,300%. One Florida estate received a valuation exceeding $700 million, despite comparable Palm Beach properties commanding far lower prices. A famous Manhattan residence featured a penthouse described as spanning 30,000 square feet, when actual measurements showed just 10,996 square feet. These weren't minor bookkeeping discrepancies or aggressive financial planning. The courts identified a pattern of deliberate misrepresentation affecting financial institutions, insurance companies, and the broader American economic system on an unprecedented scale. If this analysis is resonating with you, show your support by liking this video. When the presiding judge initially issued this determination in February 2024, legal analysts immediately recognized the extraordinary challenge it presented. Satisfying an obligation of this size would almost certainly require liquidating substantial assets. Civil judgments of this magnitude against current or former presidents are exceptionally uncommon. They don't emerge from policy disagreements or partisan conflicts. They result from courts finding compelling evidence of fraudulent conduct. According to multiple sources, events unfolded rapidly following the appeals court decision. On January 16th, merely 24 hours after the appellate ruling, the defendant's legal representatives filed an urgent request seeking a 90-day extension for compliance. The judge conducted a review hearing lasting just 47 minutes. Observers present in the courtroom noted visible frustration from the moment proceedings commenced. The exchange that followed has been characterized as among the most striking judicial confrontations in recent memory. The judge opened with measured but unmistakably firm language, addressing the lead attorney. "This is the fourth time your client has requested additional time to satisfy this judgment. At what point does the court's patience transform into complicity with delay?" The defense attorney attempted to argue that the judgment's size necessitated extraordinary measures, referencing ongoing discussions with potential financing sources and the complexities of liquidating real estate portfolios. The judge interrupted mid-response. "I've heard these arguments before, nearly a year ago. Your client has had ample opportunity to post bond, negotiate a settlement, or begin liquidation proceedings. Instead, every procedural mechanism available has been used to avoid payment while simultaneously claiming the judgment is illegitimate." What followed was described by courtroom observers as devastating. The judge denied the extension request immediately, then signed the enforcement authorization that the Attorney General's office had prepared, permitting immediate asset seizure proceedings. Drop a comment right now with your reaction. I'm genuinely interested in hearing your perspective. When that enforcement order received the judge's signature, courtroom reporters observed the defense attorney's visible shock. She immediately requested a brief adjournment to consult with her client. The judge granted only 15 minutes. This moment crystallized the gravity of the situation. Following the recess, the judge addressed everyone present with unusual solemnity. "The defendant has been afforded every procedural protection available under New York law," the judge stated. "He has had his day in court, and then some. He has appealed and lost. He has sought extensions and received them. The time for delay has ended. The time for accountability has arrived." The judge continued with particular emphasis. "This court will not stand by while a judgment debtor of means thumbs his nose at the legal system. The Marshals are authorized to proceed." This language sent shockwaves through legal circles. When judicial officers use phrases like "thumbs his nose at the legal system" regarding a former president, it indicates complete exhaustion of judicial patience. The procedural record undermines claims of political persecution, showing the defendant received more accommodations than typical judgment debtors normally receive. This isn't the first instance of aggressive enforcement against wealthy defendants. The early 2000s saw similar actions against corporate executives after fraud findings led to asset seizures and liquidation. The Madoff case provides another parallel. After that massive fraud scheme collapsed, Marshals confiscated everything: residences, vessels, artwork, even personal jewelry. The key distinction is that Madoff faced criminal charges, whereas this case remains civil despite involving similar underlying conduct regarding systematic valuation inflation for financial advantage. Remember the initial enforcement action in this very case? In March 2024, the Attorney General's office filed liens against multiple properties when the first bond deadline passed. The defendant eventually secured a reduced bond through a last-minute arrangement with an insurance company. Now circumstances have changed fundamentally. There's no bond, no extension, and no remaining appeals. The pattern is unmistakable. When defendants exhaust legal options while refusing judgment compliance, courts eventually reach a breaking point. According to legal and financial analysts who studied the case documents, the failure to comply violated fundamental civil judgment enforcement principles. Despite having an estimated net worth exceeding $2 billion, according to his own financial disclosures, the defendant failed to post required security or initiate meaningful asset liquidation. Here's the critical contradiction. Court filings reveal legal arguments claiming insufficient access to liquid assets for judgment satisfaction. Meanwhile, financial disclosures to the court showed hundreds of millions in available cash and cash equivalents. This wasn't genuine inability to pay. This was strategic delay designed to preserve assets while hoping for some political or procedural resolution. Stay tuned. The most explosive revelations are coming next. This situation extends beyond one judgment or one individual. If wealthy defendants can indefinitely ignore civil judgments through procedural maneuvering, the entire civil accountability system collapses. Once that precedent establishes itself, reversal becomes nearly impossible. The defendant's legal team faces an impossible dilemma. They serve a client who publicly insists the judgment lacks legitimacy and refuses authorization for asset sales. This means continuing courtroom battles while enforcement machinery advances. Simultaneously, they must reckon with a judge who has clearly lost patience and a chief legal officer who spent years constructing this case. They now must explain to their client why further resistance may accelerate rather than delay seizure of prized properties. The challenging reality: no credible defense remains. Either the judgment is valid, making payment or seizure inevitable, or it's invalid, requiring belief that multiple trial judges, appellate panels, and the state's highest court all erred. That position is nearly impossible to maintain legally. Legal and political analysts characterize this as a defining moment for civil accountability in America. Harvard constitutional law professor Lawrence Tribe told MSNBC that if the underlying allegations are accurate, and courts at every level found they are, then enforcement is not just appropriate, but essential. He stressed that the rule of law means nothing if judgments against the powerful cannot be collected. Even Jonathan Turley, a conservative legal scholar who frequently defends executive power, acknowledged the procedural posture leaves few options. He noted on Fox News that while he harbors concerns about the original judgment's size, legal avenues for challenging it have been exhausted. The courts have spoken. The immediate financial impact is staggering. A $540 million judgment satisfied through forced sales could require liquidating multiple major properties. Real estate experts estimate one flagship Manhattan tower alone is worth approximately $400 to $500 million, but forced sales could yield significantly less. Properties sold under legal compulsion typically fetch 20 to 40% below market value because buyers understand the seller lacks leverage. Industry analysts suggest the entire liquidation process could span 18 months to 2 years, during which additional interest would continue accruing at the statutory rate of 9% annually. This creates massive problems for the broader business empire. The organization operates on reputation and the perception of unlimited wealth. Having federal marshals seize properties shatters that image permanently. Lenders, partners, and tenants may reconsider their relationships with an organization whose flagship assets face court-ordered auction. Goldman Sachs and Deutsche Bank have reportedly frozen discussions about future financing arrangements, pending judgment resolution. Commercial tenants in the affected properties have begun consulting lawyers about lease termination clauses, concerned about landlord stability. The reputational damage extends beyond business operations. The brand itself, which the former president has valued at over $3 billion, could suffer catastrophic devaluation. Properties licensing the name in international markets may seek agreement terminations. Sources familiar with negotiations indicate at least 3 overseas hotel projects have paused discussions about renewing licensing deals. The political implications prove equally profound. A 68% majority of Americans told Gallup pollsters in December that wealthy individuals should face identical legal consequences as everyone else. Witnessing a former president's properties seized for failing to pay a fraud judgment may resonate with voters who feel the system typically favors the powerful. Republican strategists privately acknowledge that images of marshals at signature properties would prove devastating in swing states, where economic fairness resonates strongly. Drop a comment below with your thoughts. I'm genuinely curious about your perspective. Beyond immediate financial fallout, this concerns fundamental principles of American law. Civil judgments exist to compensate wronged parties and deter future misconduct. If a former president can simply ignore a $540 million judgment while maintaining lifestyle and political activities, it signals different rules for different people. The implications for the presidency itself are significant. This demonstrates that former presidents are not above civil accountability. Arguments that enforcement would somehow harm the presidential institution have been rejected at every level. Courts consistently found that allowing fraud to go unremedied would damage public trust far more than enforcing a valid judgment. This scenario is causing panic within the defendant's inner circle. Reports from sources close to the former president indicate emergency meetings have been held at his Florida residence since the appeals court ruling. Some advisors argued for finally negotiating a settlement, perhaps offering reduced payment in exchange for avoiding the spectacle of Marshals at signature properties. Others insisted any payment would appear as guilt admission and urged continued resistance. The organization is fracturing in real time, torn between pragmatism and defiance. Meanwhile, the most loyal supporters express fury at the legal system. Social media has exploded with claims of election interference and political persecution. Calls for protests at affected properties and demands that Republican officials intervene have proliferated. To the base, this represents ultimate confirmation that establishment forces are attempting to destroy their champion. Events escalated when the defendant himself responded with a series of social media posts within hours of the enforcement order. He called the judge a radical leftist and a Trump-hating judge who should be removed from the bench. He claimed the entire case was orchestrated by the current administration and Democratic donors. He specifically named the Attorney General, calling her corrupt and racist. Stay with me. What comes next will completely change your perspective on this situation. What makes this response particularly extraordinary is that it essentially confirmed no intention of voluntary compliance. Instead of announcing plans to satisfy the court's order, the reaction consisted of pure fury and personal attacks on officials enforcing it. When your defense involves attacking judges and prosecutors rather than addressing the underlying judgment, you've already conceded the legal argument. Legal experts immediately identified the problem. Norman Eisen, former special counsel for the House Judiciary Committee, noted that attacking judges who ruled against you may play well with supporters, but does nothing to stop enforcement machinery. The Marshals don't care about social media posts. This transcends one individual's financial troubles. It's about whether civil judgments have meaning in America. If there are no consequences for ignoring court orders, it signals that wealth and political power can override the legal system. Every future defendant facing large civil judgments will look to this case as precedent. It's not just about one person. It's about whether any future wealthy defendant can simply refuse to pay valid judgments while using courts for endless delay. If the answer is yes, then civil fraud victims have no real remedy. Banks, insurers, and business partners who are defrauded would know that even successful litigation may yield nothing more than paper. Constitutional scholars have weighed in as well. Yale law professor Akhil Amar told the New York Times that enforcement of civil judgments is foundational to the rule of law. He noted that the framers understood that laws without enforcement mechanisms are merely suggestions. If courts issue judgments that defendants can ignore, the entire civil justice system loses legitimacy. Here's where we stand. Federal marshals have been authorized to begin seizing assets from a former president of the United States. The appeals have been exhausted. The extensions have been denied. The bond has not been posted. This is no longer just a civil dispute or legal technicality. It's about whether the American legal system can hold the powerful accountable when they refuse to comply with lawful court orders. When judges issue enforcement orders against former presidents, when marshals arrive at iconic properties with seizure documents, we've entered genuinely unprecedented territory. If there are no consequences, it sets a dangerous precedent. Future fraudsters will know that sufficient wealth and political connections can insulate them from civil accountability indefinitely. Keep close watch on this story. The marshals are expected to begin asset inventory and valuation proceedings within days. The defendant's legal team has indicated they may seek emergency intervention from federal courts, though legal experts say such efforts have virtually no chance of success. Millions of Americans across the country are watching closely to see whether justice applies equally, regardless of political power or personal wealth. Before we conclude, make sure you're subscribed so you never miss developments like this. A former president faces seizure of his most valuable properties after exhausting every legal avenue to avoid a fraud judgment. Federal marshals have been authorized to proceed with asset inventory and valuation. The legal system that was once believed could be manipulated and delayed indefinitely has finally caught up in ways that cannot be avoided or appealed. 47 judges across multiple courts have reviewed this case. Trial judges, appellate panels, and the state's highest court have all reached the same conclusion. The fraud was real, the judgment is valid, and payment is required. There are no more legal maneuvers available. This isn't just another news cycle that will fade away. This is the American system of civil accountability being tested in real time against the most powerful defendant it has ever faced. What happens next could determine whether fraud judgments against the powerful have any meaning at all, or whether sufficient wealth and political influence can render court orders meaningless. The evidence was presented over months of trial. The judgment was rendered after careful deliberation. The appeals were rejected after thorough review. Now we wait to see if the rule of law still holds weight in America, or if we've entered an era where some defendants are simply too powerful to be held accountable.